I'm Judge Brian Cornines. I'm filling in for Judge Capper today. When you hear your name called, the first group of cases we're going to call are reviews. When you hear your name called, come down to the table on my left, your right, and we will go through your case.
Leroy Campbell, Lance Davis, Misty Dodson, Timmy Fortner, Robert Fox, Ricky May, Richard Smith, David Vance, Donald Wilson Jr.
All right, Leroy Campbell. Yes, sir. All right, State of Ohio versus Leroy Campbell, TRD 12-3025, TRD 12-2259, and CRA 10-627. All right, very good report. We'll set you back for February 27th.
Thank you, sir.
9 a.m. for review. Lance Davis, State of Ohio versus Lance Davis, CRB 2350 A and B, CRC 2339 A, B, C, and D.
Your Honor, if I may, there was community service turned in this morning. I'm not exactly sure how many hours it was.
13.
13 hours. It's not been in yet, so it won't be updated in the vote.
All right. Good report, Mr. Davis. It's not updated on in the file, but you'll get credit for the community service that you've turned in. We'll set you back for February 27th for review at 9 a.m. Misty Dotson. The State of Ohio versus Misty Dotson, PRC 23706 A, B, and C. All right. Done well, Ms. Dotson. Good report. And we've gotten some community service in. I'll set you back for March 1st.
Thank you, Your Honor.
Thank you for review at 9 a.m. Timmy Fortner. This is State of Ohio versus Timmy Fortner. CRB 25709, CRB 25301. Mr. Fortner has done nothing.
Oh yeah, I've been back and forth to Columbus. My mother-in-law's sick with cancer, and as soon as I get paid, I'm starting to do all this work.
Well,
I got community service and a few ponds.
Considerable amount of things to do here. I'm going to set you back for March 1st
Thank you.
for review at 9 a.m. And I better see some substantial progress by then, or you may be going to jail that day.
Yeah, I'll get her a lot done, probably 3/4 of it, sir. Thank you, Your Honor.
Thank you. Robert Fox.
Sir.
The State of Ohio versus Robert Fox, CRA 25100, PRC 241009, A and B.
Your Honor, Mr. Fox completed outpatient services a couple of months ago. I believe he's paid all of his fines and done his community service as well.
Okay. See on he completed,
He completed community service and his fines.
oh, that's out.
And his outpatient is completed as well.
Okay. Well, on on the TRC 241009 A and B, that case is completed. On the CRA 25-100, it looks like there's still a balance of $295.
There shouldn't be.
And that was as of 3 days ago.
That was 3 days ago.
That's just what I got.
I'm just a little lost because I'm pretty sure I paid all my fines off. But if I owe you $200 some, I will walk out of this courtroom and go pay you $200 some like right now. Like,
Yeah, it looks like there's $295 owed on this case left. So here's what I'm gonna do. I'm gonna set you back on March 1st for review at 9 a.m. In the event that $295 is paid prior to then your case will be complete and I'll show back up.
all right, yeah, I'm on my way. I can pay right this second. It's a done deal.
Thank you, Your Honor.
Thank you, Mr. Fox.
Y'all have a good one.
Ricky May. All right, this is State of Ohio versus Ricky May. CRB 25562, CRB 25-185, A and B. And
185 is closed, sir.
sorry,
I do believe 185 is closed.
I haven't gotten that far yet. All right, looks like on the CRB 25-185 A and B, it does look like that is complete, so that one will be completed, and it appears that the CRB 25-562 is also completed. All right, Mr. Manager, please go.
Thanks, sir.
Gretchen Smith. This is State of Ohio. This is State of Ohio versus Gretchen Smith, POC 22-1661, A and B. Ms. Smith is present via Zoom. Ms. Smith, it looks like you're down to $125 left on the case as far as that goes. Are you currently in treatment anywhere?
I've already completed it.
Okay. Well,
I still go to TCC for my self-locations.
okay. I'm gonna set you back for March 1st for review at 9 a.m.
Okay,
And you're down to $125 left, is that?
thank you.
Thank you. David Vance, it's the State of Ohio versus...
All right, I'll work on it.
All right, thank you. It's the State of Ohio versus David Vance, CRB 2550,
Thank you.
CRB 24597, PRC 2419, 20 A, B, C, and D. Mr. Vance, you've not really done a whole lot here.
I've had a stomach bug work through my house and all four of my kids. I do have $40 I can pay on my fines today.
All right, I'll note your $40 payment. I'm gonna set you back for review at 9 a.m. on March 1st.
I appreciate it.
And Mr. Vance, we're gonna need to see a little more out of you. You've done a lot out there, and you've had a decent amount of time to get started, so,
I appreciate it, Chairman.
all right, thank you. Donald Wilson Jr., State of Ohio, this is Donald Wilson Jr., TRC 2723 A, B, and C. Looks like all your community service is finished, and we're down to $972. I'm going to set you back for March 30th for review at 9 a.m.
March 30th?
Yes, sir.
All right, thank you.
Thank you. All right. All right, the next group of cases we're going to call are arraignments. That's first appearances on the cases. So likewise, when you hear your name called, come down to the table on your left, my right. I will go through the charges, and if it's a misdemeanor, I will ask you for a plea. You can enter one of three pleas. You can enter a plea of guilty, which means you're making a complete admission that you committed the offense charged. You can enter a plea of not guilty, which means you are not admitting that you committed the offense charged. Or you can enter a plea of no contest, which means you're not admitting that you committed the offense charged, but you're not denying the facts surrounding it, and then if I believe the state would have enough evidence, I can enter a guilty finding. If you're unsure of what you should do, you should enter a not guilty plea because it preserves all of your rights before the court. You do have the following rights. You have the right to remain silent. Anything that you say in here is being recorded and can be used against you by the state of Ohio. So if you come down front here and you decide that there's something that you really want to tell me about the case, that might not be in your best interest to do so. You have the right to have reasonable bail set in your case. You have the right to an attorney. If you can't afford an attorney, I can appoint one to represent you at state's cost. And you have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. Call for
State of Ohio versus Rebecca Stapleton, case number CRB 2636.
She is.
You'll have to have a seat. She can come up here, but you'll have to have a seat back there.
Okay.
All right, this is State of Ohio versus Rebecca Stapleton, CRB 2636. Ma'am, are you Miss Stapleton?
Yes.
All right, you were just handed a copy of your charge?
Yeah.
All right. Ms. Stapleton, it's alleged that on or about January 14, 2026, in Mason Township, that you did, being the owner, keeper, or harborer of any dog, except when a dog is lawfully engaged in hunting, accompanied by its owner, keeper, harborer, or handler of the dog, failed to combine that dog, that's an alleged violation of Ohio Revised Code Section 955.22. Failure to confine dogs, that's a minor misdemeanor. The maximum penalty on that is up to a $150 fine and court costs. Because this is a minor misdemeanor, you are entitled to have an attorney, but where you don't risk going to jail for this offense, you are not entitled to have one at state's cost. So if you want an attorney, you'd have to hire an attorney.
The thing is, this wasn't even my dog that was the
Well,
problem. My dog was on my property.
I'm
Sorry.
gonna stop you. That may all be true. We're not here for that today. All we're here on is the arraignment. So I'm going to ask you, now that I've informed you of the charge, the maximum minimum penalties involved, what plea do you wish to enter?
Not guilty.
Okay, I'll accept your not guilty plea, and we're going to set a trial in this matter. Mr. Hill, this was just filed today, it looks like. When would you want to come back for a trial? It's a minor misdemeanor. So our turnaround is,
What's this young lady's name?
it is Rebecca Stapleton.
I would like to consider what she's saying about the fact that it's not her dog before we would proceed to trial. If we could have a pre-trial, and if she wanted to bring in something to show me, because I actually have a picture of a dog, and there's a note here that says Rebecca, not owner, so I don't know what information has been passed on to us that might substantiate her claim.
Okay. Ms. Stapleton, do you want to set a pre-trial in this matter, and then that take Mr. Hill up on that opportunity?
I guess so.
Okay. All right, I'm going to set you back. I don't want to go far out, so I'm going to set you back on the 30th. And that'll be a pre-trial at 10 a.m. a signature bond of $500.
Sign right there.
And Ms. Stapleton will see you back January 30th. And that'll give you an opportunity to speak with Mr. Healy and show him any documentation that you may have. There's nothing to be upset about. This is a minor misdemeanor. You're not going to jail. It doesn't make you a criminal. I'm confident that if you speak with Mr. Hill, you'll get this worked out. Okay? All right, I'll see you back January 30th.
Your Honor,
Thank
she
you.
need to be
It's
fingerprinted.
a minor misdemeanor. She did not include it.
State of Ohio versus Marissa Raymond, case number CRB 2637.
All right, this is State of Ohio versus Marissa Ramey, COB 2637. Ms. Ramey, it's alleged that on or about January 17th, 2026, you did with purpose to deprive Walmart of your property or services, knowingly obtain or exert control over said property or services, without the consent of the owner or person authorized to give consent. That's an alleged violation of Ohio Revised Code Section 2913-02A1, theft. That's a misdemeanor of the first degree. The maximum penalty on that is up to 6 months in jail and up to $1,000 fine. How do you wish to plead?
No contest.
All right, I will accept your no contest plea. Prior to us doing the sentencing on this matter, or making a determination on that, I want to have Ms. Ramey drug screen. Is there anybody back in the back that's going to? All right, Taylor. Ms. Ramey, we're going to recall you here in a few minutes. I'm going to have, if you want to follow the lady out, we're walking out the courtroom now. We'll have you back out in a few moments.
State of Ohio versus James Connor, case number CRB 2638.
All right, this is State of Ohio versus James Connor, CRB 2638.
Yes.
All right, Mr. Connor, it's alleged that on or about January 17th, 2026, you did knowingly cause or attempt to cause physical harm to Jordan Connor, family or household member. That's an alleged violation of Ohio Revised Code Section 2919.25A. Domestic violence, the misdemeanor of the first degree. Maximum penalty is up to 6 months in jail and up to $1,000 fine. How do you wish to plead?
Not guilty.
I'll accept your not guilty plea. Do you have money to hire an attorney?
I do.
All right, so you're going to hire your own attorney. You've already been bonded, so I'll continue the bond in this matter. I'll accept your not guilty plea. How long do you think you'll need to hire an attorney?
Give me 30 days.
Okay. I'm going to set you back for a pretrial on February 23rd for a pretrial at 10 a.m.
I would assume. What date are we coming back on?
February 23rd.
We're going to request a protection order, unless Jordan Connor here, please.
State's requesting a protection order.
Yes, Your Honor.
As part of your bond, Mr. Connor, I believe there was no contact order as part of that, but there's going to be a temporary protection order issued in this case as part of your bond. You can't have any contact either directly or indirectly with Jordan Connor. Now, that can be modified or reviewed at a future hearing on this if the alleged victim in the matter wishes that to be reviewed. All right, so we'll see you back on February 23rd. 2026. If you have not been fingerprinted, I know it looks like you went to jail. If you have not been fingerprinted, there'll be an order that you appear at the jail, Lawrence County Jail. He's been fingerprinted, I see it in the file. Okay.
You said 23,
February 23rd at 10 a.m.
and at that point in time, would I just bring evidence or witnesses as to,
It's what's called a pretrial. If you hire your own attorney, they will appear with you on your behalf, and they'll be able to explain, all of those things, and they'll work with the
so
prosecutor.
if I go no contest, then I don't have to do a pretrial? We can do what we got to do?
I would recommend, based upon the severity of the charge, Mr. Conner, that you speak to an attorney.
Roger.
All right, see you back February 23rd,
23rd. What time?
10 a.m.
10 a.m.
Your Honor, that's all the arrangements we have for right now. We'll discuss the pre-trials and preliminaries.
You got a pretrial coming in the courtroom.
State of Ohio versus Meredith Holden, case number CRA 25773.
Yeah, okay.
All right, this is the State of Ohio versus Meredith Holder, CRA 25773. This is Mr. Stratton's case, and it's set as a pretrial.
Yes, Your Honor, we continued this from Friday to today. Ms. Holderby had her dates mixed up along with her husband. They both are here today. We have some issues with the video in this case. She's had problems viewing that video. I know the prosecutor's office has viewed it. I don't think Mr. Hill has viewed it yet. I'm going to get a new copy of it today. I'm going to try to upload it to Google Docs and just Google Drive and just share her a link so that she has no problem viewing that. We just need a new pretrial.
Okay, when would you want to come back, Mr. Stratton?
Within a couple of weeks, Fridays.
Yeah,
Fridays,
that's
yeah.
anytime.
About February the 9th.
That's a bad day for me.
February,
The 2nd and the 23rd are bad too.
okay. How about February 6th?
Yes, that is.
Defendant's request is matter to continue February 26th for pretrial at 10 a.m.
Did you say the 26th?
26 or 6?
Or excuse me, sorry, 6th.
6, okay. February 6th. And we might have it. Text me your email, make sure I have it, okay? And then we'll get a copy of that now, here.
Okay.
And I'm going to upload it and then share it with you. So, just have to see, his attorney received.
State of Ohio versus James McClaskey, case number PRC 19975 A, B, and C, CRC 19274.
Your Honor, this was continued from Friday. Also, Mr. McClaskey's had an issue with getting verification of community service. I think it was put on his son's. It's his community service, so I think there's some confusion to that he is working on resolving.
Your Honor, if I may, I did contact Ironton Municipal Court, and I'm expecting a call back to verify that.
All right, this is State of Ohio versus James McClaskey, TRC 19975 A, B, and C. And would you want to come back on the same day, Mr. Stratton?
Yes, that's fine, Your Honor.
All right, let's come back on February 6th.
All right.
It'll be a pre-trial at 10 a.m.
So give him a call maybe next week.
I'm going down to Arkansas now.
You're going to do, okay, all right, good deal.
State of Ohio versus Chance Balance, case number CRA 25827.
All right, this is State of Ohio versus Chance Balance, CRA 25827. Mr. Balance, my understanding is you've been in the VA
Yes.
treatment.
I'm trying to get into the more advanced treatment that's on there, but I wrecked my truck in between last time I was here now, and that's all repaired, and I just have to, I'm waiting for a call back. It'll be in a couple days.
Mr. Heald, any thoughts on this matter? Good report, they're waiting, I guess he's gonna be going to a higher level of care through the VA, but that's not been accomplished yet. I don't believe that through any part of Mr. Balance, just that there hasn't been availability yet.
Well, step number one is Mr. Balance wanting to do that. And that being the case, we're encouraged. We don't have a problem continuing this and allow him to be successful in his treatment. And we're looking to dismiss this charge eventually. We want him to go through the process and get it done. So we're okay with the continuance as long as there's a time waiver.
Okay. Is that okay with you, Mr. Balance?
Yes, sir.
All right. So there's a certain period of time that preliminary hearings have to happen in the state of Ohio, and that's within 10 days. However, Mr. Heald is offering you an opportunity to get the case dismissed if you do, take some steps that you've indicated you're willing to take. But in order to do that, to have that opportunity, he's requesting that you waive that 10-day period for the preliminary hearing, and he's going to keep the case here instead of taking it to the grand jury.
Okay.
Do you feel like you understand my explanation of that?
Yes, sir.
All right. Are you willing to waive that 10-day period?
Yes, sir.
In order to do that? Okay. I'll find that your waiver is knowingly and voluntarily done. I'm going to set you back for February 23rd for a preliminary hearing at 10 a.m. Now, Mr. Balance, in the event that you go into a higher level of care by then and you're not able to appear,
Yes, sir.
make sure that the VA lets us know that you are in that higher level of treatment, so that we'll be aware of that, and we'll continue, as long as you're continuing your treatment, continuing your progress, we'll continue moving the case for you, allowing you to do so.
Yes, sir.
Okay? All right, we'll see you back February 23rd.
Thank you, sir.
Thank you.
State of Ohio versus Tiffany Brooks, case number TRC 252131, A, B, and C.
All right, this is State of Ohio versus Tiffany Brooks, TRC 252131, A, B, and C. Like this matter is set for a pre-trial. Looks like this was Mr. Steyer's case, but I believe he has been relieved. So, Mr. Brooks, I believe, are you representing yourself?
Yeah, so I went to the Cremines office and I spoke with him. I don't know who I spoke with, but it was a man.
I was I'm Cremines, and you didn't speak with me.
Yeah,
so.
it was but the office. I don't know who I spoke with, but so I tried to hire him, but as we was talking, he was explaining to me what was going on about.
And I don't need to hear any of that stuff. Are you going to be hiring an attorney?
No.
Okay.
I can't. I can't
Mr.
afford
Heald,
it.
I've got a note here from Judge Caput that says set the trial if not resolved. I don't know if you've had any conversations with Ms. Brooks.
I haven't, but I would like to.
Okay. I'll
And
give you an opportunity.
we received the urine drug toxicology report, and Ms. Brooks was over the legal limit for THC metabolite. According to the officer, and I think it's substantiated in the video evidence, she admitted having smoked marijuana that day. So we feel like we have a pretty good case. Now, the issue for Ms. Brooks is that she had an OVI last year, so this would be a second. And I guess that we would be interested in knowing whether she would be willing to receive an assessment and do some substance abuse counseling if she would plead guilty. And you know, a second offense OVI carries with it a mandatory jail sentence of 10 days. But if Ms. Brooks felt that she had some issues with substances that maybe she could benefit by not being involved with drugs and alcohol, she could do the treatment, and if she's successful in the treatment, we would be willing to discuss with the court the possibility of her not actually serving jail time, if she's successful, if she's interested in doing that.
Yes, sir.
You want to hear, I'm going to give you a copy of it. So we'd want to have her assessed.
Ms. Brooks, you've heard Mr. Heald, the offer that Mr. Heald made in this matter. Is that something that you're interested in, or would you want to set this matter for a trial?
No, I'm interested in that.
Okay. In order to do that, you would have to take Mr. Heald up on his offer, you would have to change your plea to guilty.
Okay.
Is that what you wish to do?
Yes, sir.
All right. I will accept your guilty plea. I'm going to go ahead and enter a guilty finding, but we're not going to do sentencing at this time. What we're going to do is we're going to delay sentencing, and in the meantime, you need to get a drug and alcohol assessment taken care of. There are providers in the back, if anybody would like to do an assessment. You could meet with them today and go ahead and schedule that if you wish, and that would probably be a wise thing to do. So we're going to come back for sentencing. I'm going to go a little ways out, and that way if there's treatment recommended, and that'll give you an opportunity to go ahead and get started with that. So we're going to go to February 27th. And that'll be a sentencing at 10 a.m.
One thing I would like to add, Your Honor, and this is for Ms. Brooks' benefit, there are people who go and do an assessment and they say, I don't know why I'm here, I don't have any problems, and they're left with no choice but to say we can't recommend treatment because they didn't tell us anything. What we know is this is your second one of these in a year or so, so we know that we want them to know that, okay, because we want this to be sincere.
Yes, sir.
Okay?
And Ms. Brooks, typically they will submit reports to the court, and if they believe that you're not being sincere, they usually will put that in the report. So whether I'm here, whether Judge Capper's here, you will know based upon what they put in the report as to the sincerity of that, and that can have an effect on your sentencing. Okay?
Yes, thank you.
All right, we'll see you back February 27th at 10 a.m.
State of Ohio recalls of Marissa Ramey, case number CRB 2637.
All right, this is State of Ohio versus Melissa Ramey, CRB 2637. We're on record, and Ms. Ramey entered a no contest plea. I'm going to enter a guilty finding. We had Ms. Ramey screened. It was negative for all substances. So we're going to go ahead and proceed to sentencing. Ms. Ramey, I'm going to there'll be a $100 fine. I'll order you to pay the court costs. 10 days jail. I'll suspend all 10 days. Be 2 years level 4 probation. $30 hours community service. And I'll set you a review hearing for August 10th of 2026 at 9 a.m. If you want to write that down. If you have everything completed, you do not have to come back. But if you don't have everything completed, you got to be here that day.
Okay. And you said 30 days,
I'm sorry,
30 days community service,
30 hours.
30 hours.
Your Honor, she'll need to check with probation.
Yeah.
Okay.
And you'll have a review August 10th of 2026 at 9 a.m. You'll need to meet with probation before you leave.
Thank you.
Thank you.
State of Ohio versus Christopher Faulkner, case number CRD 25740, TRD 252866, CRD 25335, A, B, and C. Mr. Moran.
All right. So State of Ohio versus Christopher Faulkner, CRD 25740, TRD 2866, CRD 25335. And it looks like Mr. Faulkner, on about January 12th of this year, you failed to appear at a sentencing hearing.
Yeah, I called in, my cousin died on Saturday of last week, and I was with the family, so.
All right, we'll recall the warrant. On your CRB 25335, you've still got everything that you need to do on that.
Yes, sir.
Mr. Guilt's position on this, it looks like the CRB 25740 is still open.
I didn't have insurance either, by the way, so I had to, I just now got insurance and stuff where I could get back to treatment.
Are you currently in treatment?
I couldn't afford, I had a bill, I owed like $2,000 to OVP because I didn't know I didn't have insurance at the time. So I had to file for my insurance and all that. Because with my job, like if you don't get the hours, you know what I mean, every month, then it won't.
Well, I'd like to have you drug screened before we do anything else today. So. All right. If you want to, we'll recall you a little later in the docket. Mr. McCann, we're going to go with Mr. McCann, he'll take care of you.
John, we're ready to call some inmates for last State of Ohio versus Kim Busker, case number CRA 25829, CRA 25600.
This is State of Ohio versus Kim Busker, CRA 25829, CRA 25600. And it looks like Kentucky was supposed to pick you up today by 8 a.m. Very clearly, they have not. So, all right, well, Mr. Busker, I don't know if I'd necessarily say it's your lucky day, but you're going to be released today. Now, that does not resolve your warrant out of Kentucky, so you could, in theory, you could walk out the front of the jail or be released and be rearrested the same day. So it would probably behoove you to go and take care of that. You may want to check. It's got the general number from the Justice of Public Safety Cabinet, Department of Corrections. That's the cabinet level. That's Frankfurt? That's Frankfurt's what it says, but it looks like it's, let's see. You may want to start there with Mr. Willis, and then looks like it's out of Boyd County, so you may want to start with Mr. Willis, and then I would contact Boyd County Jail, and then kind of go from there. Okay? And again, I can't, force you to do that, but, you're gonna continually get picked up on the warrant as long as it's out there. So you're looking at a week here, a week there, if they decide they're not gonna come get you, so. All right, so, find that Kentucky hasn't come to pick you up by 8 a.m. this morning, and you'll be released from jail. As soon as the order goes on, and I believe you're back booked in, and then they'll book you back out. All right, thank you, Mr. Metzger.
State of Ohio versus James Dement. Case number CRA 24-290, CRB 24-635, CRA 24-786, CRB 24-787 A and B, PRD 23-1859 A and B.
All right, just State of Ohio versus James Dement. CRA 24-240, CRB 24-635, CRA 24-786, CRB 24-787 A and B, PRD 23-1859 A and B. Mr. Dement was in treatment at Hometown. Start with you, Mr. Stratton. He was at Hometown. Why is Mr. Dement coming to me from the back again?
So Mr. Dement was discharged from Hometown Recovery for medical manipulation.
I'm sorry.
For medical manipulation.
Okay.
It's all in the letter. I can tell you what it's about, but I didn't know.
Is it the letter dated January 14th? Okay. Let me read through it. Mr. Stratton, have you reviewed this letter as well?
I reviewed it the other day.
Okay. Mr. Hill, have you reviewed this letter?
I have not, Your Honor.
Give you an opportunity to read it as well.
So, Your Honor, the issue is the question of the use of the two medications together. I'm not as familiar with it, but I know they are a deadly combination, right?
Yeah, they can't be taken together.
They cannot be taken together. So he's willing to go back to treatment, but He is prescribed both of them, which presents, I mean, I don't know what to say about that.
So, our doctor prescribed him the Suboxone, and wouldn't allow the other medication to be prescribed, and he went to another provider and got the prescription for the other one, so he has two different providers for the medication, but they can't be taken together.
Based on that indication, Mr. Chairman.
No, Your Honor.
Mr. Hill, what are your thoughts on this? Because, I mean, I'll go ahead and, the last time we were here, we had a problem, or I was here, I had a problem with Mr. Dement on a treatment-related issue, and they were willing to take him back at that time. He's got several old cases.
He's got 328 days that could be imposed. Everything was wrapped up. We amended felony charges to misdemeanors, wanting to give him the opportunity to do better because we felt like he's able to. And I'm looking at the pages of, this goes back to May of 2024. Now, he's already done 30 days in jail for a prior incident in which the time was imposed and the opportunity to come back to court at a later date and ask to go back to treatment. So that's happened once. That happened on May the 9th. It's hard for me to say that I just give up on a person, and I don't want to do that, but at the same time, I think that Hometown has given up on him.
We'd be willing to accept him back into our program.
Okay, well, you ought to thank her a great deal and take this more seriously if that's the case, because they could very easily say, no, he's gone too far.
He's willing to do it. Take the medication prescribed by them and not the other one. So he's willing to cut that out.
Mr. Dement, what's concerning to me in this, and again, we kind of went through this last time, and what's concerning to me, not necessarily exactly that you went and got other medication, but that you convinced someone to give you this other medication, and you were asked about a urine screen that was submitted the previous day, and Hometown doesn't have any reason to be untruthful about this, but the response was, yeah, I'd already been taking them when I did the screen, so I did it to try and cover for myself. That's the part that's a little more concerning to me. How many days have you been in jail so far?
Your Honor, I took him into custody Friday after court.
Okay. All right. Mr. Dement, do you want to go back to treatment? And if you don't, that's fine. There's no need to waste my time, or state's time, or your attorney's time. We can just wrap it up today, and I'll give you all the jail time that you've earned, and we can just be done. I presume that you probably don't want to do that, but you're getting to the point that you're not giving me a whole lot of choice. So, I will tell you this, that the representative from Hometown might be your saving angel today, because after reviewing the letter, my intention was you were going to jail. You were going to stay in jail. I was going to amend your bond to a much higher cash surety bond that you may or may not be able to make, and you were likely just going to be sitting in jail. But given that you've done a few days in jail already, I'm going to give you one more opportunity. And when I say one more, I mean, when I'm sitting here and I read the name on the file and I know exactly who it is. That's not a particularly good thing. And, we had a long, loud discussion last time when you were here. I'm going to give you one more shot. So I will let you go back to hometown for treatment. I'm going to put you on for January the 30th for a pretrial. I am here that day. And if it's not the best report that you've ever had from there, I may amend it and send you back to jail. Have I made myself clear? All right. So I will not amend your bond or revoke your bond, and I will allow you to be released back to hometown for your treatment.
Your Honor, would it be possible to have an ankle monitor placed on him?
Have one?
I'm sure we do, Your Honor, yes. I had a long discussion with Mr. DeMint when I took him into custody, and ankle monitor's fine with me, but I think he understands that this is getting to the end of the road for him.
Yeah, with 320 some odd days, I mean, Mr. DeMint, if you were to take off and leave, you may not get picked up right away, but when you get picked up, you're going to do every one of them. Okay. All right, I won't put an ankle monitor on you at this time. And we'll see you back on January 30th for pretrial at 10 a.m.
Thank you, Your Honor.
Good luck, Mr. DeMint.
State of Ohio versus Jeremy Johnson, case number CRA 25754, CRA 25759.
All right, this is State of Ohio versus Jeremy Johnson, CRA 25754, CRB 25755. We'll start with the CRA 25754. Mr. Johnson, it's alleged that on or about November 3rd, 2025, in Mason Township, you did operate a motor vehicle so as to willfully elude or flee a police officer after receiving a visible or audible sign from the police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle caused a substantial risk of serious physical harm to persons or property. That's an alleged violation of Ohio Revised Code Section 2921.331 BC 5A II. Failure to comply with the order of signal of the police officer. That's a felony in the 3rd degree. Maximum penalty on that is up to 3 years in prison and up to a $10,000 fine. On the CRB 25755, Mr. Johnson, it's alleged on or about November 3rd, 2025 in Mason Township, you did use drug paraphernalia, 1 glass pipe with white residue. That's an alleged violation of Ohio Revised Code Section 2925.14C1. That is possession of drug paraphernalia. It's a misdemeanor of the 4th degree. Misdemeanors of the 4th degree carry a maximum penalty of up to 30 days in jail and up to a $250 fine. Do you have money to hire an attorney? Are you working?
I mean, your name is not really, not sustainable right now.
All right. I'll find that you do qualify for appointed counsel. I'll appoint Mr. Stratton to represent you. Mr. Heald, matter of bond.
Your Honor, I don't have that file, but I'm wondering how, this is a 25 case, so what date is it alleged to have happened?
November 3rd, 2025.
So he was probably not in custody in Lawrence County for that length of time unless he has some other reason for being there, but I would have thought he'd been brought before the court before now. And the reason that it looks as if everything happened at one time was because he got a paraphernalia charge, which meant he must have been arrested at some point. So I don't know what to make of the fact that he's in jail today.
Your Honor, he's picked up on a warrant.
So maybe he bonded out, I don't know.
And we had, Your Honor, we had a warrant on complaint on him.
Okay. So apparently he wasn't taken to jail that night.
Unusual, but, so we'd ask for a $5,000 cash and surety bond.
Okay. I will go ahead and set bond at $5,000 cash as surety. Mr. Stratton is appointed. Mr. Stratton, I'll give you an opportunity to speak with Mr. Johnson. We'll go ahead and set. Well, I will let you fully set up preliminary, Mr. Stratton. I will let you speak with Mr. Johnson. And we'll go ahead and set it for January 26th at 10 a.m. for a pre-trial and preliminary hearing. And if you wish to have the matter recalled on bond, after you've spoken with him, you can have the matter recalled. Okay, yes, sir.
State of Ohio versus Anthony River, or driver, case number CRV 2640A.
All right, this is okay. This is State of Ohio versus Anthony. It's captioned River CRV 2640A and B. Mr. Heald, the defendant has indicated that his last name is Driver.
We'd move to amend the complaint to reflect that, Your Honor.
All right, I'll find that there's scrivener's error and complaint will be amended to reflect that it's Anthony Driver. All right, Mr. Driver, it's alleged that on or about January 18th, 2026, you did knowingly cause or attempt to cause physical harm to Dana Denny, a family or household member. That's an alleged violation of Ohio Revised Code Section 2919.25A, domestic violence, a misdemeanor in the first degree. Misdemeanors of the first degree carry a maximum penalty of up to 6 months in jail and up to $1,000 fine. On the B case, it's alleged that on or about January 14th, 2026, you did knowingly cause Dana Denny to believe that said Anthony Driver would cause serious physical harm to the personal property of Dana Denny. That's an alleged violation of Ohio Revised Code Section 2903.21. That is aggravated menacing. That is a first misdemeanor of the first degree. Maximum penalty on that as well is up to 6 months in jail and up to $1,000 fine. How do you wish to plead?
I plead guilty on it. I just want to come and get my stuff from the house. It's my property. We split up and I think my property. And we both got off vacation.
Well, hang on, I'll let you tell me all about it here in just a second. Are you sure that you want to enter guilty pleas to these charges?
Yeah.
All right. I will accept your guilty plea to each charge, and I will enter a finding of guilty.
Sorry, Your Honor.
I was letting you, I'm assuming that's the alleged victim.
It is.
You do not need to speak.
Your Honor, I don't know how far the discussion had gotten with Mr. Driver as far as counsel and things of that nature.
Well, he entered guilty pleas to both charges.
Oh, okay. Well, one thing I know is that Ms. Denny's going to want a no contact order. Our recommendation would be 60 days in jail with, I don't think we'd make a recommendation as to how many days to actually serve at this point, but I think that needs further discussion.
Okay. How many days has Mr. Driver served?
Yeah, I do work full-time.
All right, so 3 days in. All right, so you've done 3 days, Mr. Hill, at this point.
One thing we want to make sure of is there's no further problems. He made mention of the fact that he just wanted to get his stuff, so I don't know, can that be done without you all getting into you having a problem with him again?
The only thing he has left there is his dog because he took all of his clothes.
Yes, I just let him come in my dog and just beat me. I have a full-time job. I just want to get on my wages.
Can someone else get the dog for him? Can Danny get the dog and bring it to you?
Yes.
And did he turn my tags in? He took my tag.
And your tags?
Tags
That's fine.
off the truck. He's supposed to take them to the jail. Danny was supposed to take them somewhere.
All right,
I do work full-time.
we're going to move to sentencing at this time. There's a guilty plea entered and a guilty finding. Already paid the court costs. Let's do 60 days in jail. I'll suspend 57 and give you credit for the 3 that you've done. There'll be a $100 fine. Two years, level 4 probation. And I'm going to give you 30 hours community service as well. There'll be an order for you to stay away as part of your probation, stay away and have no contact with Dana Denny. That's D-A-N-A. Last name Denny, D-E-N-N-E-Y. Be released today. On the B case, it'll be a $50 fine, 60 days jail, 57 suspended, credit free. And it'll be concurrent, 2 years level 4 probation, and the cases that are running concurrently with the A case.
She says it's March the 11th, not April the 11th.
Your Honor, if I may, it's like my attention to the date of birth.
I said, when I came in, they said it was 4/11. I let them know it was 3/11, but they said, when I'm on my ID, that's what they got to walk off.
311 is right.
I will amend his date of birth to 3/11/1989. Driver, that'll be the order of the court. You're going to have a review hearing set for August 10th of 2026 at 9 a.m. And if you you have everything done in this case by then, you don't have to appeal, but if you don't, then you're gonna have to show up here and explain why you don't have it all done. You'll need to speak with probation, and then I'm presuming that they will take you back to the jail, put you back in, and then put you back out, and you'll be released to back out.
Jimmy, I told you about my friend. Just make me laugh. Oh,
State of Ohio versus Logan Wright. Case number CRB 24512, A&B.
All right, this is State of Ohio versus Logan Wright, CRB 24512, A and B. And Mr. Wright.
the first time for it.
All right, so Mr. Wright left treatment.
Yes, Your Honor. Left like hours after being released from jail.
That was the second time. The
Yeah.
first time was 4 hours after being released.
And I don't know if Your Honor is familiar with this case, but he was sentenced to 180 days on 12/5/2025, 158 days, sorry. On 1/9/2026, he was released to Focus. He still has 124 days that he had not spent. They let him out to go to treatment. It's the recommendation of the probation department that he goes back to jail for the 124 days.
All right. All right. Well, that may be an option at some point. Here's what I'm going to do, at least initially. I'm going to appoint, well, you've already been sentenced, so how many days does he have remaining?
124 days, Your Honor, of the previous sentence that was posed against him.
All right. Mr. Reif, I'm going to go ahead and impose the time that you have remaining, 124 days. However, I'm going to be willing to review this after you have spent some time.
Your Honor, if I may, they advised me when they called me over the weekend they was arresting him, that there may be additional charges on him. Did they file any additional charges that you know of?
He does have charges on municipal currently, municipal court. I'm not aware of what they are. He does have court today through the municipal court.
Okay. All right, I'm going to impose the 124 days. That'll be the order of the court. And I will consider reviewing this on February 23rd. At 10 a.m. At that time, Mr. Reif, I'll determine whether I let you go back to treatment or you're going to continue. I don't know what's going to become of anything with Gavin and I are doing, but at that point, we'll determine whether we're going to go back to treatment or we're going to start all of it. All right. See you back February 23rd.
State of Ohio recalls Christopher Faulkner, case number CRB 25740, CRD 252866, CRB 25335, A, B, and C.
So the state of Ohio is Christopher Faulkner, CRD 25740, CRD 252866, CRD 25335, A, B, and C. Mr. Faulkner had failed to appear when we had him tested. You were negative for all substances, Mr. Faulkner. And so because of that, we're going to call the warrant. I'm going to set you back. February 27th. First sentence in here.
Thank you.
All right, we'll see you back then, Mr. Faulkner. Thank you.
State of Ohio versus Jimmy W. Sparks, who's back in holding, case number CRB 2639. Jimmy Sparks.
All right, this is State of Ohio versus Jimmy Wayne Sparks, CRB 2639. Mr. Sparks, it's alleged on or about January 17th, 2026, you did the purpose to deprive Walmart, the owner of property or services, knowingly obtain or exert control over said property or services, to wit miscellaneous merchandise, without the consent of the owner or person authorized to give consent. That's an alleged violation of Ohio Revised Code, Section 291302A1. That's theft. That's a misdemeanor of the first degree. Misdemeanors of the first degree carry a maximum penalty of up to 6 months in jail and up to $1,000 fine. How do you wish to plead? Guilty. All right, I'll accept your guilty plea and enter a guilty fine. Mr. Field, term of sentence.
Your Honor, this is a theft from Walmart.
Correct.
So I guess we would request a drug screen to determine what the disposition should be.
All right. Well, we're going to have you back out for sentencing here shortly. Mr. Sparks, we're going to have you drug screened before I determine what your sentence is going to be. All right. Is there going to be anything come back in your urine?
Yeah. My taste is awesome. Also, I haven't had recently, but
okay.
It probably won't be in the drug screen. I don't know if it be. It's been around since I was
All right. Well, then we're not going to screen him based upon his own statement. I think that would more than qualify. We need to
I have prescription for Suboxone.
Okay.
Your Honor, he's got a Chillicothe address. Is that where you live? Where are you living now?
No, I live on 141. Like right at the beginning of 141.
Okay.
I know the address, and if you need the address.
Here's what I'm gonna do then. Before we go further, I'm gonna have you assessed for treatment. Anybody do? Saw lots of hands first. I saw Jesse's hand first, so.
He may be getting some, I mean, he's got Suboxone, so it may be.
Are you
already in treatment?
Treatment currently?
I was in OVP, I got out of OVP, and I went to Restoring Hope, transitioned from Restoring Hope to actually to my house. And when I got a job and everything, like, this was just a big fuck up, like, on my part, I'm sorry for cussing, man. I don't drink, for a while, that night I drank, and I went in Walmart, I don't know why I even did, I don't steal, I work every day, I don't.
All right, here's what I'm gonna do. I'm gonna have Jesse from hometown do an assessment on that, and then we'll have him back out for something. All right. We'll call you a little later in the docket.
State of Ohio versus Tyler Watts, case number CRB 2641.
All right, this is State of Ohio versus Tyler Watts, CRB 2641. Name, are you Tyler Watts? Okay. Ms. Watts, it's alleged on or about January 16th, 2026, you did with purpose to deprive Walmart, owner of property or services, knowingly obtain or exert control over such service, property or services, to wit, miscellaneous merchandise without the consent of the owner or person authorized to give consent. That's an alleged violation of Ohio Revised Code Section 291302A1, theft. It's misdemeanor in the first degree. Misdemeanors in the first degree carry a maximum penalty of up to 6 months in jail and up to a $1,000 fine. How do you wish to plead? All right, I'll accept your guilty plea. Mr. Hill, on sentencing.
Your Honor, we would ask that she take a drug screen to determine what issues she might have that we could help her with.
Okay. Ms. Watts, I'm going to order you to take I'm going to accept your guilty plea and her guilty finding. I'm going to have you drug screened to see what comes back in your urine. However, if you know that there's going to be some things come back, if you tell me now, we can skip that step. Okay, what's going to come back in your urine? All right. We'll skip the urine screen then. We're going to do an assessment on you and have you back out a little later in the docket before session. Okay? We're going to have a drug and alcohol assessment done.
State of Ohio versus Matthew Hoff, case number TRC 26136A and B.
Matthew Hoff. Hoff, H-O-F-F. All right, this is State of Ohio versus Matthew Hoff, CRA 2642A, CRA 2642B, and then TRC 26136A and B. Mr. Hoff, it's alleged that on or about January 18th, 2026, you did operate in Fayette Township, you did operate a vehicle, streetcar, or trackless trolley within the state in violation of Division A of Section 451119 of the Ohio Revised Code, when one or more children under 18 years of age are in the vehicle, streetcar, or trackless trolley, while the defendant is considered to be under arrest for operating a vehicle under the influence of alcohol, drug use, or a combination of them, or for operating a vehicle with a prohibited concentration of alcohol, a controlled substance, or metabolite of a controlled substance in the whole blood, blood serum, or plasma, breath, or urine, in violation of Section 2919.22C1 of the Ohio Revised Code, endangering children. That is, the endangering children in this case is a felony of the 5th degree. Maximum penalty is up to 1 year in prison and up to a $2,500 fine. In CRA 2642B, on or about January 18, 2026, in Fayette Township, it's alleged you did operate a vehicle, streetcar, trackless trolley within the state in violation of Division A of Section 451119 of the Ohio Revised Code, when one or more children under 18 years of age are in the vehicle, streetcar, or trackless trolley, while the defendant is considered to be under arrest for operating a motor vehicle under the influence of alcohol, drug abuse, or a combination of them, or for operating a vehicle with a prohibited concentration of alcohol, a controlled substance, or a metabolite of a controlled substance in the whole blood, blood serum, plasma, breath, or urine, in violation of Ohio Revised Code Section 2919.22C1, endangering children, felony of the 5th degree. Felony of the 5th degree carries a maximum of up to 1 year in prison and a $2,500 fine. CRA 2642C is on or about January 18th, 2026 in Fayette Township. You did operate a vehicle, streetcar, trackless trolley within the state in violation of Division A of Section 451119 of the Revised Code, when one or more children under the age of 18 are in the vehicle, streetcar, trackless trolley, while the defendant is considered to be under arrest for operating a vehicle under the influence of alcohol, drug abuse, or a combination of them, or for operating a vehicle with a prohibited concentration of alcohol, a controlled substance, or a metabolite, a controlled substance in the whole blood, blood serum, plasma, breath, or urine. It's an alleged violation of Ohio Revised Code Section 2919.22C1, felony 5th degree, endangering children. Maximum penalty is up to a year in prison and up to $2,500 fine. In TRC 26136A and B, it's alleged that on or about January 18th, 2026, in Fayette Township, you did operate a motor vehicle under the influence of alcohol, drug abuse, or a combination thereof, with one prior offense within the last 10 years. That's an alleged violation of Ohio Revised Code Section 451119. That is a first-degree misdemeanor. Maximum penalty on that's up to 6 months in jail and up to a $1,375 fine. Or excuse me, a $1,575 fine. And it also carries an up to 5-year license suspension, interlock plates, and immobilization of the vehicle if it's registered to you. Minimum penalty on that is 10 days jail or 5 days jail and up to 18 days home confinement, a $525 fine, a 1-year license suspension. On the B case, it's alleged on the same date in Fayette Township, you were operating a motor vehicle and failed to control that vehicle. That's an alleged violation of Ohio Revised Code Section 4511.202. That is a minor misdemeanor. The maximum penalty on that is up to a $150 fine and court costs. You have money to hire an attorney. Are you working currently? All right, I'll appoint Mr. Morford to represent you. Mr. Hill, matter bond.
State requests a $25,000 cash or surety bond.
All right. I will go ahead and set bond at $25,000 cash or surety. However, in the meantime, I'm going to go ahead and get Mr. Hawk assessed in this matter. So who would want to assess Mr. Hawk in this matter? All right. Taylor, do you want to do it?
I don't have any mail bids.
No beds available? Okay.
Thank you, Sheriff.
She's. All right, Mr. Morford, I'm gonna set bond at $25,000 cash surety. I'm going to, I'm gonna go ahead and have him assessed. You can have that recalled on the matter of bond, but I'm gonna go ahead and set a preliminary hearing on January 26th. At 10 a.m.
State of Ohio versus James Gray IV, case number CRB 2644 A, B, and C, CRB 2643, TRC 133791 A and B, and TRD 133713.
All right, this is State of Ohio versus James M. Gray IV, CRB 2644 A, B, and C, CRB 2643, TRC 133791 A and B, and TRD 133713. All right, we'll do the new charges first, Mr. Gray. Mr. Gray, it's alleged that on or about January 16th, 2026, in Fayette Township, you did, knowing that an official proceeding or investigation is in progress or is about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation. That's an alleged violation of Ohio Revised Code Section 2921.12A1, tampering of evidence. That's a felony of the third degree. Maximum penalty on that's up to 3 years in prison and up to a $10,000 fine. On CRA 2644, it's alleged on or about January 16th in Fayette Township, you did knowingly obtain, possess, or use methamphetamine, a Schedule II controlled substance. That's an alleged violation of Ohio Revised Code Section 292511 AC1A. Aggravated possession of drugs, that's a felony of the fifth degree. Felonies of the fifth degree carry up to 1 year in prison and up to a $2,500 fine. In CRA 2644C, it's alleged that on or about January 16th in Fayette Township, you did use personal identifying information, including but not limited to the following: the name, address, telephone number, driver's license number, commercial driver's license number, commercial driver's license number, state identification card, state identification card number, social security card, social security number, birth certificate, place of employment, employee identification number, mother's maiden name, demand deposit account number, savings account number, money market account number, mutual fund account number, other financial account number, personal identification number, passport or credit card number of a living or dead individual, without the express or implied consent of the other person, shall use, obtain, or possess any personal identifying information of the person in violation of section 2913.49A2 of the Ohio Revised Code. That is identity fraud. It's a felony in the 5th degree. Maximum penalty on that is up to 1 year in prison and up to a $2,500 fine. And then in CRB 2643, it's alleged that on or about January 16th in Fayette Township, you did with purpose to deprive Walmart, owner of property or services, knowingly obtain or exert control over said property or services, to wit, miscellaneous merchandise without the consent of the owner or person authorized to give consent. That is an alleged violation of Ohio Revised Code section 2913.02A1, it's theft. It's a misdemeanor in the 1st degree. Maximum penalty on that is up to 6 months in jail and up to a $1,000 fine. Do you have the money to hire an attorney?
No.
Do you wish to be considered for appointed counsel?
Yes.
Are you working?
No.
All right, I'll appoint Mr. Stratton to represent you. I'm going to set a preliminary hearing for January 26th and pretrial. Mr. Hill, do you wish to be heard on the matter of bond?
Yeah.
Yeah. We'll set bond first, and you can have a review.
Your Honor, given the fact that the allegation involves the possession of dangerous drugs, as well as some other serious offenses, we would not oppose an OR bond if Mr. Gray were to also be assessed and enter into treatment. And we would also ask for a GPS monitor if he's to be released. Otherwise, we'd want a $5,000 cash surety bond.
Okay. He's got a parole holder, so a bond may be academic at this point.
Yeah, I have a bond, you'll be able to do with the parole. Yeah, and that's, he'll still be assessed, he's doing the June Street. Yeah, I know. And we'll do that. Whether parole would like to send him to treatment with that parole.
Okay.
No issue on rain, we'll see one or the other. That way, what we've done in the past.
Okay. Well, Mr. McCann, do you want to assess Mr. Gray? All right. I am not going to set a bond at this point. I'm going to wait until he's assessed, and we'll recall this a little later in the document.
State of Ohio versus Andrew Thompson. Case number CRA 2646, TRD 26144, A, B, and C.
All right, this is State of Ohio versus Andrew Thompson, CRA 2646. Mr. Thompson, it's alleged on or about January 19th, 2026, in Union Township, that you did knowingly obtain, possess, and use buprenorphine, drug involved in the violation of the compound, mixture, preparation, or substance included in Schedule 3, 4, or 5 controlled substance. Previously has been convicted of a drug abuse offense in violation of section 292511 AC2A of the Ohio Revised Code, possession of drugs felony in the 5th degree. Felonies in the 5th degree carry a maximum penalty of up to 1 year in prison and up to a $2,500 fine. Mr. Thompson, do you have money to hire an attorney?
I have a job, I don't know to specific, income requirements off of that.
Okay, are you paid hourly?
Yes,
How much you paid per hour?
$13.50
How many hours a week do you get?
a week.
Do you have any attendance?
No.
All right. You're right on the line. I'm going to find that you qualify for that. You've also got in TRD 26-144 A, B, and C. On or about January 19th, 2026, in Union Township, it's alleged that you were operating a motor vehicle without a valid driver's license. That's an alleged violation of Ohio Revised Code, Section 4510.12. It's a minor misdemeanor, maximum penalty is up to $150 fine and court costs. Same date, same township, it's also alleged that you were operating a motor vehicle without a safety belt. That's an alleged violation of Ohio Revised Code, Section 4513.263B1. That is also a minor misdemeanor. It is a statutory $30 fine. And then on the same date, same township, it's alleged that you were operating a motor vehicle with expired tags. That's an alleged violation of Ohio Revised Code, Section 4503.11. It's a minor misdemeanor. Maximum penalty is up to $150 fine and court costs. All right. Based upon your qualification, I'm going to appoint Attorney Sean Stratton to represent you. I'm going to set a preliminary hearing for January 26th. Mr. Heald, matter of bond.
Your Honor, the reason this is a felony charge is because Mr. Thompson had a prior drug conviction. Otherwise, this would be a misdemeanor. It's buprenorphine, which I believe is Suboxone. And so I don't know whether this is a situation where we're going to find out he has a prescription. I haven't read closely enough on the report to find anything like that out. So I guess I'd like to know more about the situation. We're not opposed to an OR bond. I guess the question is, should he be assessed for treatment?
I mean, I can be assessed by treatment. Your Honor, I just would like to get to work tomorrow if it's possible. That's all. Thank you.
Your Honor, I think it would be a case where a signature bond is appropriate, you wouldn't get assessed by treatment. Where we really want to get assessed at.
All right, I'll set bond at $2,000 OR bond in the matter. Mr. Stratton, we can either come back, I was going to originally come back for preliminary hearing on January 26th, but given that he's going to be out, if we're going to waive that 10-day period, we can come back later and get some more time to work on that.
We'll wait a 10-day period.
So I'm going to set you out a little ways, Mr. Thompson. I'm going to set you out for February, you said 23rd to 5 for you, correct? February 27th. For a preliminary hearing, pre-trial. I'm going to order that between now and then, Mr. Thompson, you go seek out a drug and alcohol assessment. You can use the provider of your choice, which you're going to be out on bond. But you'll need to have that accomplished prior to coming back.
Is my medical card covered the assessment fees?
Typically, yes. I'm seeing nods back there, so I'm assuming yes. And you'll need to have that done prior to coming back. Yeah. I've set you out over a little over a month, so that should give you plenty of time to do it. All right. Thank you, Mr. Thompson. See you back February 27th at 10 a.m.
State of Ohio versus Sheree Bryant. Case number CRB 2645.
Mr. Stratton, could you clerk report? Yeah, that, I'm doing it, film problems. Yeah, no ops, something else, so we do All right, this is State of Ohio versus Shirley Bryant, CRB 2625. All right, Ms. Bryant's alleged on or about January 19th, 2026 in Fayette County. He did cause or attempt to cause physical harm to Aaron Tucker in violation of section 2903.13A of the Ohio Revised Code. That is assault. It's a first-degree misdemeanor. Maximum penalty on that is up to 6 months in jail and up to $1,000 fine. How do you wish to plead?
Not guilty.
All right, I'll accept your not guilty plea. Are you going to hire your own attorney?
We have Crystal Lauder.
All right. And I'm going to set you back February 23rd at 10 a.m. Staying, if once you heard from Mr. Lauder on that, he may move that if that doesn't work for his calendar. All right, I'll let you sign a $2,000 OR bond.
We're going to request a protection order too, Your Honor.
All right, and I will grant a temporary protection order to the benefit of Aaron Tucker. E-R-I. And Ms. Bryant, you won't be allowed to go around or have any contact at any time with Ms. Tucker.
Your Honor, will she need fingerprint?
She will. You'll also have to appear, Ms. Bryant, at the Lawrence County Jail to get fingerprinted. All right.
Okay.
We'll see you back February 23rd at 10 a.m.
Okay.
State of Ohio versus Sarah Kingery, case number CRB 25806. Mr. Morford's case, Your Honor.
All right, this is State of Ohio versus Sarah Kingery, CRB 25806. Mr. Morford's case set for pretrial.
Your Honor, she called the office early this morning, said she would not be able to make it. She was sick. I don't have any supporting documentation for that.
All right, Mr. Hill.
We're not opposed to a short continuance under the circumstances.
You give us a week, Judge?
Why don't we do this? Are you here the 30th, Mr. Morford?
I'm sorry?
Are you here the 30th?
Yes.
All right. I'll continue this at defendant's request to January 30th for pretrial at 10 a.m.
Thank you, Judge.
Thank you.
State of Ohio versus Jeremy Maynard, case number CRB 25774. Also Mr. Morford's case.
All right, this is State of Ohio versus Jeremy Maynard, CRB 25774. This is Mr. Morford's case set for pretrial. This is as a co-defendant in this matter. And Mr. Morford, I presume that you're going to want to keep this on the same day?
Please.
All right, Mr. Stratton, what day was that?
February 6th, Your Honor.
Okay. Defendant's request, set this matter for pretrial on February 26th at 10 a.m.
6th.
Oh, February 6th, sorry. February 6th at 10 a.m.
Here you go. We'll see you then. Yes, sir.
Thank you.
State of Ohio recalls Tyler Watts, case number CRB 2641.
The Tyler Watts from Holding. All right, this is State of Ohio, this is Tyler Watts, CRB 2641. And Watts entered a guilty plea, it was a guilty finding earlier. We were having her assessed prior to proceeding with sentencing. Did you do an assessment on it?
Yes, we will accept her in services with us.
Okay. What was the recommendation of the?
We would like her to come into residential.
Ms. Watts, is that something you're willing to do? All right, so here's what I'm going to do. I'm going to delay the sentencing in this matter. I'm going to let you sign a $2,500 OR bond. And you're going to be released to treatment, inpatient treatment. And ma'am, what?
Focus.
Focus, that's right, sorry. Inpatient treatment with focus. I'm going to set you back on February 27th for sentencing hearing. Now, the reason I'm doing this is twofold. So if you do well in your treatment, you're going to get a better outcome on your sentencing. If you go into treatment and you leave, there's 180 days whenever you get picked up on the warrant. There's 180 days out there that I can impose, and you can sit in jail for 180 days. So you've got the option, we're giving you a chance to do treatment and get better, or the other option is you spend 180 days in jail. You can sign no OR bond, but the order will be released to focus for inpatient treatment. We'll see you back February 27th at 10 a.m. All right. Thank you, Ms. Watts.
State of Ohio versus Matthew Hall, case number CRC 26136A and B, CRA 2642A, B, and C.
All right, this is State of Ohio versus Matthew Hoff, PRC 26136A and B, CRA 2642A, B, and C. Previously, we had set a $25,000 cash surety bond, and Mr. Medford has asked this to be recalled. Mr. Hoff has been assessed.
That's what we're recalling from the judge. He can't make that 100% bond. He can't make that.
Okay. What did the assessment come back at?
Due to circumstances, we are not able to take him due to being a registered sex offender, but I have reached out to another provider that will be able to take him. His name is Greg, and he works for TBC Wellness, and they will be able to come and take him.
Okay. Any idea when they would be able to take him?
Today.
Today?
Mm-hmm.
Okay. Mr. Hill, your thoughts?
Oh, okay. I was thinking he was the one that had the parole holder.
No.
Well, this is a very serious situation. As a matter of fact, it's alleged that he was traveling at speeds up to 90 miles an hour with the kids in the car, and he was highly intoxicated. So, and an indication that he was suffering from mental distress because of personal family type situations going on. We're a little bit cautious based on the fact that the seriousness of this, and we don't want to see him leave treatment and try to do something else reckless in that regard. So we would ask for an ankle monitor if he's going to be released.
Okay. And what was the name of the provider?
TPC Wellness.
TB or P?
TPC,
Okay.
yes.
All right. All right, Mr. Hoff, I'm going to amend bond to 5,000 OR, allow you to be released to treatment at TPC Wellness. You're going to be on a GPS monitor, so you won't be able to be released until that GPS monitor is in place. Now, I want to caution you about a couple of things. You are going to be required as part of your bond to be there and to stay there and complete and work through your treatment. If you cut the ankle monitor, there'll be a separate felony charge that is actually more serious than the felony charge that you're facing. And so if you cut that monitor and run, you're going to be in county police court. You're going to get charged with tampering with evidence, which is a third-degree felony, which carries 3 years in prison. And both judges up there typically will make you do all 3 years in prison if you cut a monitor. And I want to make that very clear up front, so I don't want if you do something crazy or something you shouldn't do, cut the monitor and run. I want you to understand that is in addition to anything else that you might come out of this case. I don't know whether, Mr. Hill is planning on trying to keep the case here and let you work through it here as not being a felony, or if he plans to take it over as a felony. But if you cut the monitor and run, it will 100% be a felony, and you will most likely, and when I say most likely, I mean, I've never seen them not give someone 3 years in prison on that charge. And if you think I'm kidding, you can ask Mr. Morford. He practices in that court, those two courts all the time.
3 years. If you cut the monitor, you're going to prison for 3 years.
So I wanted to make sure that you're aware of that and clear up front. That way you can say, no one can say you want more. So I'm going to go ahead and set you back on January 26th for preliminary hearing at 10 a.m. And if you are in treatment, they will bring you. And then we will figure out where this case goes from there, Mr. Hall.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
State of Ohio recalls Jimmy Sparks, case number CRB 2639.
State of Ohio versus Jimmy Wayne Sparks, CRB 2639. Mr. Sparks and their guilty pleas, or guilty plea to the charges in the guilty finding, and we were having him assessed prior to determining where we go from here.
Okay, I spoke with Mr. Sparks, and he does qualify for residential treatment.
Okay. Mr. Sparks, is that something that you'd be interested in doing? I see you nodding your head, but
Yes, sir.
we're recording. I just need an audience. Okay. All right. So what I'll do then, Mr. Sparks, is I'm going to set you in a 2,000 OR bond with the condition that you be released to treatment at hometown recovery. I'm going to set your next hearing for February 27th. and that'll be a sentencing hearing at 10 a.m. And as I told the other lady that was in a similar situation as you, I haven't sentenced you yet, so there is 6 months in jail that I can impose. If you do well in your treatment, you're going to get a much more favorable outcome. And I would anticipate you not going back to jail. Okay? But if you don't, or if you leave treatment and you don't complete it, then I've got a 6 months I can impose and then would likely impose and you just have to lay it out. Okay? All right. See you back February 27th at 10 a.m.
Thank you,
Don't have to stay in jail for them, or?
No, they're gonna come pick you up for treatment. All right, thank you.
Edible Highway calls James Gray IV, case number CRB 2644, A, B, and C, CRB 2643, TRC 133791, A and B, and CRB 1337.
Yeah, we can take them. We can take them on those on parole.
All right, this is State of Ohio versus James Gray IV, CRB 2644, A, B, and C, CRB 2643, TRC 133791, A and B, and TRD 133713. And we're having the matter called on the matter of bond. If you can.
We can take them.
All right.
I know he's on parole out of Gallia County, and I kind of know Joe Jagger a little bit. When court's over, I'll call up there and see what they say. Y'all gonna give him an OR with ankle monitor treatment, see if he's good with it.
Okay. Mr. Stratton?
Your Honor, we can put this back on Monday, maybe. That next year,
Okay. All right, I'll set bond at 5,000 OR, release on a GPS monitor, RRS. Now, Mr. Gray, obviously you have the parole holder, so that warrant stays in effect until they decide what they're going to do with it. So even though I've given you an OR bond here, you're going to be held on that unless and until they figure out what they're going to do. If they remove that and allow you to go to treatment, then at that time, once that's removed, you would then be permitted to be picked up by RRS. I'll tell you the same thing that I just told the last gentleman. You're going to go on a GPS monitoring device. In the event that you cut my monitor on that, in our common police court, if you cut the monitor, you're going to be charged with tampering with evidence. They give everybody who does that, they are 3 years in prison. It doesn't have anything to do with me. I'm not down there, but I've practiced in that court, and I've seen other people that practice in that court, and I've never seen someone get less than 3 years for cutting a monitor. And that 3 years would be in addition to anything that you might receive in this case. So we're giving you an opportunity. I don't know whether Mr. Hill's intention would be to keep that here or to take it to common police court. We don't determine that today. But I can promise you if you cut the monitor, it's going there if you cut the monitor. All right. So that'll be the court's order. I'll set it for a pretrial and preliminary hearing on January 26th at 10 a.m.
All right.
All right. Court's adjourned.
Little delay is for the Mac.